Welcome to this evening's PDAC webinar, Antitrust for Australia, Asia, Important Competition Law Considerations in Recent Mining Mergers Around the World. This is the 12th of 16 sessions in the Fasken series. My name is Michael Barassa, and I am a partner in Fasken's Toronto office and a member of the PDAC Program Committee. This is Fasken's 11th annual PDAC seminar series. This year we're doing it virtually like PDAC itself, which started yesterday. We have people joining us earlier today for the first antitrust session, and I welcome back our panel presenting this time to audiences in Asia and Australia. So good morning to our viewers in that part of the world. We're also broadcasting this on YouTube live, and so welcome to all of our viewers. Before I begin, there's a few housekeeping items. For the online survey at the end of the webinar, please click the survey link underneath the video to fill out our survey. Your input is greatly appreciated. For questions during the webinar, if you have a question, please type it into the chat box beside the video. Today's panel will do their best to answer all of the questions. For technical support, if you require that, please click the tech support button, which is located under the question chat box. And for materials, the speakers' bios and materials from today's webinar can be accessed from the materials button under the video player. And now I'll turn things over to Tony Baldanza, who is a competition law practitioner in our Toronto office, who will moderate today's session and introduce our panel. Take it away, Tony.
Thanks very much, Michael, and hello, everyone. Thank you for joining us. We're very fortunate indeed to have recruited for this session 4 outstanding competition lawyers and the immediate past head of the Canadian Competition Authority to discuss competition issues pertaining to mining mergers around the world. Our panel is comprised of the following. Katrina Groshinski is a partner with MinterEllison based in Sydney, Australia. Katrina regularly deals with the Australian Competition and Consumer Commission and advises clients on transactions requiring foreign investment approval. She's got a wealth of experience in highly regulated industries, including mining. And now I should note that Katrina may well have to leave the program at some point due to an unanticipated event that she has to address, but we will, of course, carry on. Our apologies in advance. Amadeu Ribeiro is a partner based in the New York office of Mattos, Filho, a leading Brazilian firm. Amadeu has been ranked one of the top 40 antitrust lawyers in the world and is highly experienced in assisting clients in navigating Brazilian competition and regulatory law. My colleague John Pecman at Fasken is Senior Business Advisor in the Competition Marketing and Foreign Investment Group, and he's based in Ottawa. Before joining Fasken, John served as the Canadian Commissioner of Competition. That's the top competition enforcement officer in the country from 2013 to 2018. And before that, he served in pretty well every unit at the Canadian Competition Bureau, including mergers and cartels. JunHe is a partner with JunHe based in Beijing. Janet has more than 25 years experience providing advice to clients in a wide range of industries, including natural resources. And she's widely regarded as one of the leading competition lawyers in China. And finally, Josh Shapiro is a partner in the Antitrust Competition and Distribution Group at Thompson Hine, based in Washington, D.C. Josh routinely guides clients through the review of M&A transactions by the U.S. agencies, the FTC, and the Department of Justice. He is also Thompson Hine's go-to person for strategic advice and counseling for U.S. and foreign clients on critical competition questions. Let me spend a moment on our format. Each panelist will provide a high level, let me emphasize, very high level, overview of the antitrust merger control framework in her or his jurisdiction. We will then discuss recent important developments for mining mergers in an interactive format. And we will then conclude with a Q&A session. We encourage you to put any questions you might have in the question box, and we will do our best to answer them. I'd be remiss if I didn't point out the materials we have on the site. You will see in the material box a multi-jurisdictional merger control table that the panelists assembled for all the jurisdictions in which we will be discussing. Some of the panelists have developed slides. We have an article on merger control, and importantly, the biographies of the various panelists. So with that, I propose to get underway with our high-level overviews. And I would ask Katrina Groshinski to begin with respect to Australia.
Thanks very much, Tony. It's a real privilege to be on the panel. I really enjoyed the earlier session this morning, so very much looking forward to this one as well today. So just in the brief overview, I really wanted to cover three things from an Australian perspective: the who, the what, and the when. In Australia, as Tony mentioned, the who is the Australian Competition and Consumer Commission. They're a very well-established, independent statutory body. They're well-resourced. They are led by a group of commissioners. Rod Sims is the chair. He has been the chair since 2011 and provides real leadership to that group. The Commission is the body that is solely responsible for giving first-level clearance to all mergers in Australia. In terms of the what, the Competition Consumer Act merger provisions look at any acquisition of shares or assets. There are no monetary thresholds involved at all. It doesn't matter what the shareholding size is either, so it can also attach to minority shareholdings, and it also extends to joint ventures. In terms of the when, engagement with the regulator is required. A notable feature of the Australian regime compared to other regimes is that there is no mandatory notification obligations at all. And in fact, the scheme is entirely informal. So that is, if you look at the Act, you won't find anything in there about the merger clearance process that almost all the mergers in Australia are processed through. The ACCC does issue guidelines to help parties navigate the process, and those guidelines give, as a helpful suggestion more than anything, that where a merger involves parties that have products or services that are complements or substitutes, or where the combined market share of the merged entity is likely to be greater than 20%, then they would expect that parties would notify the ACCC of the merger. That said, it is very much a qualitative exercise in Australia, taking into account for example, areas of particular sensitivity or interest to the Australian regulator, which certainly would include mining, anything to do with energy, oil and gas, or telecommunications, just as a couple of examples. The result of the ACCC positively clearing a merger is not immunity under the informal system, but in fact a letter of comfort, which basically says that the Commission will not take any action in the event that the parties go to complete the transaction. The relevant test is whether or not the acquisition would result in the substantial lessening of competition in any market in Australia. The ACCC takes a fairly liberal view to what market in Australia means, including markets in which Australia is where Australia is a participant in a global market. Substantial was really taken to mean where the impact would be meaningful on competition. And the way in which the ACCC looks at it is to conduct a with and without test. What does the future look like for competition if the merger goes ahead compared to if it doesn't? In terms of timing, again, there is no set mandatory timeframes within which the Commission must make a decision. Rather, the Commission gives guidelines for what we call a phase 1 here, of where the Commission looks at a merger that includes market inquiries that typically will take 6 to 12 weeks. If the Commission then determines that they will need to look further and have concerns, they issue a statement of issues, and then the guidance is that there's another 6 to 12 weeks involved. One trend that we have seen definitely over the last 3 or 4 years, really, with the Commission here, and Rod Sims has led this, is to slow the process down, in the sense of, Rod would say, not be a hostage to parties' transaction timetables. The Commission has made it clear repeatedly they will take all the time they need, they think, to reach the right decision. And just finally, there is another process in Australia by which you can obtain merger clearance called authorisation. That has only been in place 3 years. It has been used, but very infrequently. That involves a slightly different test, which is, in the event that the Commission finds that a merger would result in a lessening of competition, that lessening is then balanced in a public interest test to see whether the public interest factors outweigh any lessening of competition. If the ACCC is satisfied of that, then it is a full immunity that is granted, in contradiction to your letter of comfort in the informal process. But that said, the informal process really is the dominant one. It's well established in Australia and used by the Australian business community. The final thing I'll say is, in terms of remedies, if a party is unsatisfied with the ACCC's decision, they have to take action in the federal court to seek a declaration that their merger won't contravene the Act, or in fact get the ACCC to take action to stop them completing the transaction. In the alternative scenario, with the authorisation, there's appeal on error of law to a specialist body called the Australian Competition Tribunal. Thanks, Tony. I'll stop there so we can keep going with the other jurisdictions.
Thank you very much, Katrina. Over to you, Amadeu, relation to Brazil.
Thank you, Tony. Thank you. And good evening, or good morning, or good afternoon, depending on where you are. It is really a pleasure to join this distinguished group of panelists. I will cover briefly the overview of Brazil as a country where mergers may be reportable under certain conditions. We also have a suspensory review regime, like many other jurisdictions, and transactions are notifiable if they satisfy certain thresholds. In fact, there are 3 tests that must be met for a transaction to be reportable, and I will cover each one of them briefly. In Brazil, the authority is known as CADE, that's the Brazilian Antitrust Authority, CADE. CADE comprises 2 departments, the General Superintendents and the Tribunal. The General Superintendents it has the power to review and clear mergers without remedies. If a case requires remedies, then it goes to the tribunal. Only the tribunal has the power to approve a case subject to remedies or to block transactions. The thresholds, as I was just discussing, there are 3 tests, and so the first one is the so-called effects test. That is, transactions need to have a nexus with Brazil. Usually that is the case when the target business has a local presence or exports to Brazil. Then there's the so-called concentration test. The concentration test is, I would pay special attention to it in Brazil because what a concentration is under Brazilian law differs, I think, from other jurisdictions. So it's not only mergers and acquisitions that will be deemed concentrations in Brazil, also joint ventures defined in a rather loose fashion, and minority shareholding acquisitions, and so-called collaborative agreements may fall under this definition of concentration. For minority shareholding acquisitions, the rules to keep in mind are if you are acquiring 5% or more and there is a horizontal or a vertical relationship between buyer and target, then you have a potentially notifiable transaction. If you're acquiring at least 20%, then and I should clarify, it's either total shares or voting shares, then you have a reportable transaction. Collaborative agreements, the meaning of that under Brazilian law is parties need to be competitors. They need to then get together in a common enterprise where they will be sharing risks and profits. And if the agreement has 2 years or more, then you have a potentially notifiable transaction. And then finally, the so-called revenue thresholds. If one, and in Brazil, it applies to the group revenues of the parties involved in the deal. So if one group has roughly $140 million in revenues in Brazil, annual revenues, and the other group 14 million, then you meet the thresholds, and then you're subject to a filing. The review period in Brazil can go anywhere from 30 calendar days to 330 days. The fast track proceeding, which covers transactions that don't raise any competition concerns, applies to transactions where typically there will be no overlap, where the combined market shares will not exceed 20%. In those cases, you can apply for the fast track, and you will get a clearance decision in 30 calendar days or less. In cases where combined market shares exceed 20%, or where you have substantive antitrust issues, then you have a longer review period. The typical review period under the so-called ordinary proceeding is 60 to 90 calendar days from filing. Cases that are more complex, and especially cases requiring remedies, may go well beyond that. And then it's difficult to provide you with an estimate because every case is different, and you don't have enough cases in the category such that an average would be truly meaningful. And so it's really a case-by-case assessment. And it can range anywhere between, say, 90 calendar days and 330 calendar days. Finally, just a very brief note. The substantive analysis is, I think, very much in line with the type of analysis that is done in major jurisdictions like the EU and United States, and obviously Canada, although I realize that there are some differences, but substantively it's very much aligned with these jurisdictions. And finally, last but not least, remedies, where there's a general preference for so-called structural remedies, but I think, as we will be discussing today, behavioral remedies, there's some flexibility there on the part of Brazilian authorities to accept them. That's my introduction, Tony. Back to you.
Thank you very much, Amadeu. I'll now turn to John Pecman in relation to Canada. John.
Thank you, Tony. And it's great to have a second run at our panel with my esteemed colleagues and to learn more and more about the merger process in other jurisdictions. So the Competition Act establishes jurisdiction for the review of all mergers in Canada. The Act is administered and enforced by the Commissioner of Competition, who's currently Matthew Boswell, former Crown prosecutor. with the support of his agency, the Canadian Competition Bureau, which is an independent law enforcement agency. And while the Commissioner and the Competition Bureau investigate and evaluate mergers, only the Competition Tribunal, it's a quasi-judicial body made of a federal court judge and economist and a lay member, can issue a formal remedial order with respect to a merger. So Canada has this bifurcated approach to investigation and adjudication of mergers. The Bureau has very broad powers to investigate, including ability to subpoena documents, examine witnesses under oath, and the tribunal has the power to dissolve mergers or order divestitures. And a breach of a tribunal order may be punished by contempt proceedings. And the appeals from a tribunal decision go directly to our Federal Court of Appeal, and from there to the Supreme Court of Canada. All mergers with a nexus to Canada, regardless of their size, are potentially subject to investigation by the Commissioner. High-value mergers meeting statutory review thresholds must be notified with our Competition Bureau, unlike Australia, where it's more voluntary. Under current thresholds, where purchaser and the target together have assets or combined gross revenues from sales in Canada exceeding $400 million, and where the target business has assets or gross revenues from sale in Canada that exceeds $93 million, this proposed transaction must be notified with the Competition Bureau. And the transaction must observe all applicable waiting periods, unless a pre-clearance is obtained through another process called the Advanced Ruling Certificate, which is available only for non-competition issue mergers where there's no competitive overlap, and they're rarely handed out by the Bureau because they are an immunity from challenge. Statutory waiting periods will not commence until a complete filing has been made, and the initial waiting period for the parties is 30 days, before which the parties often receive a no-action letter for non-complex matters. So for the vast majority of mergers, 30 days is not reached. The decision by the Bureau or this comfort level letter is given within 14 days. And I would say that's over 90% of transactions that are filed with the Bureau. And they receive approximately 225 on average per year to look at through this notification proceedings. And for some of the more complex transactions where there are serious competition issues, after the 30-day period, parties can expect to receive a supplementary information request known as a SIR. This formal information request triggers a second 30-day waiting period, which only commences following the completion by both of the parties of the respective SIR responses. They have to complete all the information. Sometimes for complex transactions which raise competition concerns, the Bureau review has extended beyond the second waiting period. In these cases, the Bureau can request and the parties can agree to extend the waiting periods pursuant to what they call a timing agreement. In the alternative, if parties don't agree to this extension, the Bureau can seek an order or an interim order from our competition tribunal to delay closing. So at any point during the review, a remedy can be offered by the parties and accepted by the Bureau to correct for competition concerns. And where the Bureau believes that a proposed merger is likely to result in a substantial lessening of competition, it'll generally seek to reach a negotiated settlement with the parties, which will then be registered with the competition tribunal in the form of a consent agreement. So the Bureau tries to avoid litigation for merger transactions because they're awfully fatal, often very fatal to a merger because it really delays the closing, and parties just often abandon if it gets into a full contested process in Canada. As I mentioned, if we can't reach a settlement with the Bureau, they can apply to the tribunals and seek a remedial order. In some of their cross-border transactions, the Bureau, where we're reviewing other jurisdictions in Canada, typically US and EU, the Bureau will assist on a similar type of remedy, but it'll have to be registered in Canada. However, if there are no unique Canadian assets or issues involved, often the Bureau will just accept foreign remedies to deal with issues in Canada as well. Last thing I wanted to mention on this is that gun jumping, starting to consummate the merger before closing, can result in investigation and severe penalties. So be careful not to commence the integration before closing. I think that's really important in all jurisdictions, not just Canada. The substantive test is pretty common across jurisdictions where the competition analysis is trying to determine whether or not the merged entity will have market power. And in layman's terms, market power means the merged company will be able to control prices after the merger. They'll be able to increase prices. And the Bureau conducts an econometric modeling analysis to help them determine whether the parties will have that kind of ability. But there are some simple guidelines that the Bureau does provide in its merger enforcement guidelines in terms of when parties can expect a serious review. So transactions where the post-merger market share in a product market is over 35%, we'll see a deep dive, as well as when combined market shares of the top 4 firms is at 65% or greater. There is concern about coordinated effects, and the Bureau will take a real close look at that deal as well, because they're worried about cartel behavior after the transaction. Another reminder for people engaging in mergers that care should be taken in the preparation of internal documents, company documents, and emails regarding the proposed merger. Often, companies try to sell the deal to the board of directors, and they engage in hyperbole, talking about all the benefits from the deal, including their ability to corner the market or raise prices after the fact. And these types of documents can be fatal to a transaction. The Bureau considers them hot documents and could crater the transaction. So care needs to be taken about describing the transaction. And lastly, what differentiates Canada from other jurisdictions is what we could describe as our explicit efficiencies defense, where cost savings from a merger, if they're significant and they are greater than any harm from a transaction, the competition tribunal must allow that deal to go through. So this is a very unique feature to our law and something I'll talk about a bit later, Tony. So thank you very much.
Thank you, John. That's terrific. So Janet, I wonder if you could take us through an overview of the situation in China.
Yeah, thanks a lot, Tony. Thank you very much for Fasken organizing this panel. And it's an honor to talk to the audience and also work together with the prestigious panelists. For China, we started the antitrust law in 2008. And it was rather confusing because we had 3 antitrust agencies at that time, and the Ministry of Commerce at that time took care of the merger review. Fortunately, we have merged the 3 agencies into one in 2019. In the past, when Markham had the review, it has to consult the other 2 agencies, although they only are responsible for investigations, but it has resulted in substantial delay. Now, it seems that the process is much quicker, especially for simplified procedure. Under Chinese law, the merger review is mandatory, and so no transaction can be closed before a clearance is granted by SAMR, the State Administration of Market Regulation. The concentration that's defined in China that trigger merger, other than merger and also acquisition of shares and assets, it also increased the contractual arrangement. So that increased all kinds of JVs. There's no distinction between full function and non-full function. And it also increased other types of contractual arrangement, which is particularly applicable for mining industry, which they may not have even a partnership or other unincorporated entity. So SAMR takes quite a wide interpretation of what may constitute contractual arrangement. The other thing that will trigger filing is whether you meet the turnover threshold. The threshold is actually quite low in China. Each of the undertaking entity, if in last year's revenue is less than $60 million US, which is renminbi 400 million, and if the aggregate number of the undertakings is more than 10 billion renminbi worldwide, or 2 billion renminbi in China in last year, then a filing will be triggered. In terms of the procedure involved, we have the so-called pre-acceptance period. It's probably similar to the pre-notification or waiting period. This period of time, there's no statutory limitation. And so sometimes it will be quick, a few weeks, and then you have the statutory period of phase 1, 2, 3 kicks in. Sometimes it could be very long, 3 to 4 months. And so we always try to work with the regulator to initiate the formal acceptance as quickly as possible. For the phase 1 is 30 days, phase 2 is 90 days, and for phase 3 60 days. For simplified procedure, now is a common trend that SEMA will clear that within phase 1. So it will take a relatively shorter time. It could be 6 to 8 weeks, or sometimes it will be 3 months maximum. However, for normal procedure case, other than the pre-acceptance, which may be 2 to 3 months, and the statutory period for 6 months, so a total of 6 to 8 months. If the regulator needs more time, we have to pull and refile. And so for normal procedure with conditions imposed, generally we are talking about a year or even longer. In 2018, the average time for the conditional approval is 420 days. 2019 is 390 days. For any cases that may be competition concerns, we need to build in a longer period of time in order to allow the approval to be granted. In terms of the remedies that may be imposed in China, as you may be aware, other than the structural remedy, actually behavioral remedy is very common for China. Fortunately for the mining cases, we only have one case, the acquisition of Extra by Glencore. But for that case, you can see that for remedies to be imposed, you do not need to have a very high market share. It's quite particular for that mining case because the Chinese regulators say we heavily rely on import of the minerals from overseas. And so even with market share data less than 30%, we have remedies imposed, and we can have structure and also behavior remedies. The behavior remedies range from all kinds of creative ideas, and sometimes it's also involving very general condition like you do not abuse your dominant market position, and the friend principle has been widely used in all circumstances. At the same time, we also need to be aware that for non-notifiable mergers, it will also trigger investigation if the regulator thinks that there may be competition concerns. And gun jumping is a focus of the investigation in last few years. And the regulator has started the first case for Canon Toshiba investigation, which says that for a series of steps involved in a transaction, it may be regarded as a gun jumping if you do not do the merger review and obtain the clearance for the first step, even if there's no control involved in the first step. And so we have to watch out for a series of transactions as to whether a gun jumping may be a concern. And lastly, in terms of the merger review for high profile and sensitive cases, we have to start early preparation and be more strategic. And we can talk about that more in the coming panel. Thanks a lot, Tony.
Thank you, Janet. Excellent. Over to you, Josh, to cover the overview for the United States.
Thank you, Tony, and it's a pleasure to be here today again with you in the panel. I'll try to be brief here. I think we've all had a lot of law thrown at us, so I know the last thing you want is to go through the intricacies of the U.S. Statutory regime and merger review. However, here we are, and what I would say is that, to start off, Section 7 of the Clayton Act is really the principal U.S. statute governing mergers and acquisitions. And its principle also in the fact, given its age, it's enacted first in 1914 and amended in 1950. So it's been around for quite some time. And Section 7 prohibits acquisitions of stock or assets where the effect of that acquisition is to substantially lessen competition or tend to create a monopoly. Section 7, obviously, as I mentioned, applies to stock or asset deals, but also applies to joint ventures as well. And the statute that a lot of practitioners and as well as businesses might be aware of, if you have deals that sort of touch on the United States, is the HSR Act, which stands for the Hart-Scott-Rodino Antitrust Improvements Act of 1976. That was enacted to really give the federal agencies that are responsible for reviewing mergers and acquisitions in the United States, which are the Federal Trade Commission and the Antitrust Division of the Department of Justice, the opportunity to review the antitrust implications of deals prior to those acquisitions being completed. Now, the HSR Act requires parties to file notifications with both the FTC and DOJ and observe a mandatory 30-day waiting period. The HSR rules, I will just forewarn you, are hyper-technical, and there are a number of exemptions, many of which can apply to foreign purchasers, as are relevant to a lot of our audience here. And those need to be evaluated by counsel. But broadly put, most transactions over what the current size of transaction threshold is, which is $92 million, will be reportable. At least that should be your starting presumption. Then you can try to find an exemption from there. This size of transaction test is adjusted annually based on the change in gross national product. Actually, this past year was one of the first years in really since the 2008 crash in which the threshold decreased. So that was a notable change this year. One interesting thing about the US statutory regime and the HSR Act is that transactions that are not necessarily reportable under the HSR Act, either because the thresholds themselves aren't met or an exemption applies, are still subject to Section 7, which is that original sort of the grandfather of this whole antitrust regime. And they may be exempted, they may be investigated and ultimately challenged by the US antitrust authorities. So unfortunately, that's cold comfort to a lot of businesses, which means that there's no statute of limitations as well. So the agencies can go back later and challenge deals that either were never reported or frankly that were reported that never got that were never investigated when they're going through the process. The one sort of solace here is that it's a little harder to challenge those deals, not necessarily from a legal perspective, but just practically. The DOJ and FTC really won't go after deals that are consummated unless there's serious antitrust issues and some serious concerns, really because sort of the mantra is it's hard to unscramble the eggs. One other interesting thing to note about the US regime is that private plaintiffs can also bring suits to enjoin proposed transactions and also seek damages on completed transactions. I'm not going to go into too much detail on process, other than to say that, as I mentioned before, there's a 30-day waiting period during which you can't close a transaction. That 30 days is actually 15 days in the case of a cash tender offer or in certain acquisitions in bankruptcy court. There used to be, and I say used to be, as of a month ago, there was a early termination program where transactions that didn't really raise any substantive issues, if the parties requested, the waiting period would be terminated early. It was no guarantee of that, but there was a program to review those such transactions. Currently, that program is on pause with no real understanding yet of when that will return. In terms of process going forward after the 30 days, so really at the end of that 30-day waiting period, the agency has to decide. When I say the agency, it could be either the DOJ or the FTC, as they have concurrent jurisdictions over mergers. Typically, though, one agency has experience in a particular industry, and generally you'll see, for example, with mining, the FTC generally reviews mining mergers. At the end of this 30-day waiting period, if the agency decides that it still has issues, it'll issue what's called a second request, which is akin to phase 2 investigation in many other jurisdictions. And then there's a whole process. It takes months to substantially comply with that second request. And then the parties can then put the agency, once they've substantially complied, put the agency on the clock and force it to make a decision whether to let the waiting period expire or go to federal court to try to block the transaction. Second requests can take months to resolve. Obviously, as rather than substantially comply, the parties can always switch to a remedies discussion with the regulators, which is something parties often do. But one point, and John mentioned this earlier, that I think bears repeating, is that particularly in the U.S., documents really are key. Internal documents, as those are sort of generally what investigations by the FTC and DOJ rise and fall upon and sort of determine whether they'll pursue a case. Because what the parties think about the transaction, how they view the market, how they view their competitors is really something that is critical to any merger review in the US. And back to you, Tony.
Well, thanks very much, Josh. That's great. So having established essentially the overview of the merger control regimes in the various jurisdictions, we're now going to cover a range of issues that appear in probably all the jurisdictions in one way or another. But what we'll do is we'll just cover a couple of issues for each jurisdiction and then conclude with a general canvas of the panel on a couple of other issues. So let me begin with Katrina. Katrina, and to our audience, of course, mining companies frequently secure financing by selling minority positions in themselves. And in recent years, competition authorities around the world have been paying increased attention to minority interests and the competitive effects of those minority interests. I understand there have been developments in that regard in Australia. Perhaps, Katrina, you can describe the situation in Australia and any guidance for our audience. Thanks very much.
Sure, thanks very much, Tony. Yeah, like a number of other jurisdictions, the ACCC has had a real focus on minority interests because we don't have any formal thresholds, monetary or shareholding thresholds. The ACCC has given some guidance and said that businesses should be alert to the minority shareholding, even if you're talking about in the range of 10 to 20%. They tend to look at the issue qualitatively. So what degree of influence or control, even if it's not formal control from a corporation's law sense, might the acquirer have post the transaction? And the type of issues that they've said that they're worried about is a softening of competition between rivals, changing the incentives of firms, the opportunities for greater coordination, information sharing. We've got a live issue in Australia at the moment with Qantas, which is our national airline, having purchased in 2019 another airline called Alliance Airline, much smaller than itself, that has a particular connection to the mining industry because basically it operates charter flights and scheduled flights for fly in, fly out workers in mines around the country. Qantas just completed that transaction. They didn't think that it needed to be notified. The ACCC then subsequently found out about it and started an investigation. And they've gone so far as to issue a statement of issues, which is the beginning of our phase 2 process usually. And the issues that they've raised are that they are concerned that Qantas will have a reduced incentive to compete, that its shareholding will mean that it can have an influence over the extent to which Alliance can raise additional funds, for example, to compete more effectively with Qantas. And also Alliance has a number of arrangements with Virgin, which is Qantas's major domestic competitor, and they're worried it'll soften that competition. And that has now passed into the enforcement area. So it's a very good example of the Commission not just looking at what is put before it, but actively scanning the market to see what has happened that it should be worried about. Picking up on the point that I think Josh made about unscrambling what has already been done, there's only one case I'm aware of in Australia where a completed merger has been undone, and that was many years ago. But this one is certainly one that everybody is watching very closely in that respect.
Thank you, Katrina. Another topic for Australia. It's not unusual in mining transactions to acquire, as part of the assets or included in the shares, infrastructure, rail lines, port facilities, etc., or exclusive entitlements, etc. Those acquisitions can themselves give rise to competition issues. Can you comment about developments in Australia in that regard, please?
Yeah, thanks very much, Tony. As you said, those rights are often regarded as very valuable. Access to railways or coal terminals, for example, at ports, or in fact just related port services as well. And in fact, the ACCC, when they looked at the proposed BHP Rio merger some time ago, markets for rail services and port services were two of the markets they looked at. And the general issue that they're concerned about is a vertical integration foreclosure one, that being able to control either access to a critical means of transport for getting a competitor's product to market, or being able to control how much of the limited supply of capacity, whether it be terminal capacity or rail haulage capacity, rivals might have access to, is also another way in which competition could be lessened. And Australia has a number of either contractual-based regimes or statutory regimes which often govern access to this, which were commonly regarded as addressing the competition issue related to infrastructure. But if a few years ago, the ACCC, in a transaction involving railway assets, basically said it undermined the effectiveness of those regimes and said that the competition issues had to be looked at afresh. More recently, last year, they did actually seek to prevent a merger between two parties, Pacific National and Horizon, which, if completed, would give control of a major rail terminal hub to Pacific National, and they lost that case. I should just say quickly, the ACCC has taken a number of merger cases in the last 20 years, and they've lost them all, including 3 in the last sort of 3 years, and they are starting to seriously advocate now for a change in the test. But I'll leave it there, Tony.
Thanks very much, Katrina. So, Josh, turning to the situation in the United States, market definition in mining mergers, not precisely as is the case with mergers in really all industries, is often central. I understand that in the United States, in the Peabody Arch Resources transaction, market definition was essentially the decisive element. Perhaps you can describe the situation and the takeaways for merging parties.
Absolutely. So this is actually a very recent case. This is, as people on our audience may be familiar, this is a proposed joint venture between Peabody Energy and Arch Coal just about a year ago that would have combined the parties' respective coal mining and sales operations in the Southern Powder River Basin, which is in Northeast Wyoming. So the FTC challenged this, and they claimed a very narrow product market definition. Again, this is not the geographic market definition, it's the product market definition, which is coal mined from the Southern Powder River Basin, which so it's sort of one in the geographic definition sort of blended into the product one. But really what the FTC alleged here was that the proposed joint venture would eliminate head-to-head competition between these two suppliers, which were really the two largest in the region, and two of the largest coal mining companies really in the United States. The parties' combined share of the basin's coal reserves and coal production would have exceeded 60%. And notably, the federal district court, which is a federal district court in Missouri, granted the FTC's request for a preliminary injunction. And the deal was ultimately abandoned. And this was the only deal formally prohibited in 2020 in the US, meaning that a district court granted a preliminary injunction to stop the deal from going forward. Other deals, of course, were abandoned, and other actions were brought by the agencies, but this is the only one that made it all the way through a hearing in federal court, at least last year. And as you mentioned, Tony, market definition was key. Once you had sort of defined the market so narrowly to coal from the Southern Powder River Basin, and you had a 60% market share, there really wasn't much of an argument that the defendants could make at that point to argue that there wasn't anti-competitive effects. What was a surprise here was that there was a feeling going in that, and the defendants had made these arguments, but there was an industry recognition that, particularly over the last several years, that coal used for electricity faced competition from other sources, namely natural gas and other renewables like wind and solar. And the court actually acknowledged that. The court said, yes, that competition did exist. But ultimately the court found, it has to follow what's called the narrowest market principle, which that means that even though there may be other markets and there's a broader market perhaps where coal competes with natural gas, renewables, and like wind and solar, they're distinct submarkets. And under the Clayton Act, ultimately, if the joint venture causes substantial competitive harm in one of those submarkets in which the defendants compete, that makes the joint venture illegal under the Clayton Act, at least if you can show substantial lessening of competition. And the court was quite thorough in going over all those factors, and it used standard quantitative approaches that you see in most merger matters, which is a hypothetical monopolist test. Again, it looks at things like whether the merging parties could impose a small but significant non-transitory increase in price. It looked at qualitative approaches that have been laid out in Supreme Court opinions, looking at the practical indicia of a market, and ultimately found that it was this very narrow market.
So Joshua, what was it, at the risk of extending the dialogue, and maybe it's too much inside baseball, but what is it about Southern Powder Basin coal that is distinctive? We're talking about thermal coal, right?
We are talking about thermal coal. I mean, right. Again, the judge, which was surprisingly was a Trump appointee, which was again another surprise here. Went through all the factors, and the FTC put together a very strong quantitative case where they showed that that there was, based on the relevant supply and demand factors of that particular coal, you had production facilities elsewhere around the United States that were configured to use the coal from this region. And again, the defendants came up with very good counter arguments, but ultimately, these factors ultimately led the court to find that the FTC had met its burden.
Thanks. So predictably, the advent of the Biden administration has generated a lot of speculation about antitrust reform, both in terms of enforcement policy and possibly even legislative reform. Can you comment on that and what might reasonably be expected?
Sure. There's lots of speculation, both in the United States and abroad about what's to come here in the United States with antitrust enforcement. Right now we don't really quite know what the leadership at the DOJ and FTC will look like, or frankly, what Biden's specific enforcement priorities will be. What I would say is that Biden is already under quite a bit of pressure from progressive critics of corporate consolidation to, avoid appointing lawyers that would be seen having cozy ties to the industries that they're overseeing. There was a lot of pushback, particularly in the big tech sectors, about that. And so one might think that a lot of the sort of enforcement will be on areas like big tech and consumer-facing industries. But again, there's been a push here. There's a bit of a tidal wave in the United States, both from the left and the right, oddly, maybe for slightly different reasons. Sort of thinking maybe perhaps corporate consolidation is going in the wrong direction. So there is quite a bit of concern that challenges like in the Peabody Arch Coal matter will continue. And we'll see more of those in the future, particularly as certain industries like the coal industry in the United States find it harder and harder to survive absent consolidation with their competitors. And like you said, there's also potential for legislation on the horizon. Senator Amy Klobuchar, who you may recall was one of the presidential candidates on the Democratic side of the ticket, has introduced a comprehensive bill that would have strengthened merger review. This would actually, Senator Klobuchar would proposes to amend Section 7 in the Clayton Act to sort of create a lower standard rather than just substantial lessening of competition. It would create a standard that would for prohibit mergers, would create an appreciable risk of materially lessening competition. It's slight change, but enough to sort of give the government a bit of a advantage in that respect. Also, for certain deals, currently the burden's on the government to prove their case. For certain deals, I won't go over all the specifics, but particularly larger transactions, the proposal would put the burden on the merging parties to prove that their deals do not lessen competition. Again, that's a big seismic shift in how we've been practicing antitrust law in the United States, if that went through. Again, this is to reiterate, this is proposed legislation, and Senator Klobuchar has proposed similar proposals in the past, but she does have a pretty significant role. She's now the head of the Senate's Antitrust Subcommittee, and this actually also comes on the heels of a report by the Democratic House Subcommittee recommending even more sweeping changes to antitrust law. So I think the next few months, and particularly the next year, will be very instructive to see where things go, not just during the Biden administration, but over the next several administrations.
Thank you, Josh. I suppose we should all read her book.
Yeah,
yes.
I'm not going to plug anything, but perhaps so, yes.
Right. Okay, thanks very much. Janet, I wonder, with respect to China, so multi-jurisdictional transactions, I understand, engage unique considerations before SAMR. I wonder if you could comment on that. Thanks very much.
Yeah, thanks a lot, Tony. Yes, indeed. I mean, for multi-jurisdictional merger review, the issues with China, the first one is about timing. We're quite well known in the market, not in a positive way, that China, we should be the first one, but normally we will be the last out. And one of the reasons is that SAMR has been quite active in terms of talking and coordinating with regulators of other key jurisdictions in the merger review, mainly with European Commission, but they also look at like US, South Korea, Japan, and sometimes also quite remote countries. And it is quite common that they would like to know what are the concerns in other jurisdictions, and to make sure that they do not overlook any issues that they should consider. And so in some extreme cases, SAMR may ask for copies of the RFIs and also responses in other jurisdictions, especially in Europe. And they would not grant clearance until they make sure that the clearance for other jurisdictions are obtained. And so for multi-jurisdiction, timing-wise, we have to be very cautious. But at the same time, I mean, there will be also, I mean, political considerations involved in the merger review. As you may be aware, especially for the US government, when it was, I mean, the president is Trump, we have experienced that sort of a tension between the governments, and some cases may be upheld, causing very long delay, or even there's chance that it may be blocked. And so that kind of tension is a political consideration. It does not just involve US. In the past, it involved Japan and South Korea. And lately, unfortunately, the relationship with Australian government is also not good. And so, I mean, we have to watch out for that. Instead of, I mean, imposing remedies, or say there may be a competition concerns, it's quite common that SAMR may hold a review process. And so it will be quiet. For example, in the latest case that I just handled, it has been quiet for more than 6 months. And so the parties are forced to pull and refile. And so sometimes this kind of, say, non-action and no approval from SAMR may kill the deal. And so, and of course, and sometimes it may also give rise to a conditional approval. Structural remedy may not be workable, but in quite a number of cases, the parties would make concession and agree to behavioral remedies. And so the assessment period could be very long. And what we normally recommend the parties is that before actually submitting the filing to SAMR, we can do things in advance to tackle this kind of potential non-competition issues. The first thing is that SAMR is also, I mean, does not like to be seen as a political tool, and it's quite common that they may engage their economists to do the analysis to support that there is competition concern, which from our perspective may not be justifiable. And so we also recommend the parties to engage economists to tackle those technical issues in advance. The second thing is that, I mean, there may be other leverage points that the parties can do. For example, to engage Government Affairs Council, whether they have that internal resources, or if not, they hire third-party professionals so that they can look at that from other ways involving, say, the diplomats or the local government, and to negotiate with, I mean, SAMR in terms of the possible way to resolve the political concern. And sometimes this may work, so the leverage from other resources may help to get through. Of course, the behavior remedies is also another way to solve the issue, because SAMR also do not want all this kind of transaction to be blocked or abandoned because of the political tension. And so that sort of trading with conditional approvals, conditions may be also a workable way to resolve this issue.
Well, thank you, Janet. So switching to another topic in relation to merger control in China, mining joint ventures are, of course, very common. I understand that in China, there's a perhaps not a unique, but an important perspective in relation to joint ventures, and that joint ventures may encounter particular challenges in securing clearance. Any thoughts there?
Yeah, thanks a lot, Tony. In fact, for reviewing joint ventures, in the past, SAMR probably take a more relaxed attitude because, I mean, they care more about the merger or acquisitions. But lately, they started to have tighter scrutiny because they think sometimes the JVs may be just a disguised cartel arrangement among the competitors. And in fact, they have created quite an alarming precedent case. In one JV, that's the Zhejiang Garden Biochemical High-Tech and Royal DSM. I mean, SAMR has taken a very strict scrutiny in terms of the markets involved, and also they strongly believe that this may be a collusion between the competitors. And so they have imposed quite a number of behavioral remedies. in order to ensure that, there's no such kind of a horizontal agreement to be reached. And they have strong view that it has caused anti-competitive effect to the market. In fact, before this case was out, there's no conditional approval for JV alone. All the cases related to merger and acquisitions. And so I think it's also particular that SEMA would like to give this kind of precedent case a warning to the market that when you are dealing with the JV, you have to be very careful. Of course, for mining JVs, normally people may think that for production JVs, it will be less problematic than sales or marketing JVs. That's also the situation in China. However, for production JV, sometimes SEMA may look further down the road again, it's similar to the gun jumping case. They think, you may have different stages in terms of the JV operation. And so they will also look further as to what may happen in terms of the sales and marketing activities in the future. And so the efficiency rationale for the production JV may not work that much in China. They can go further down the road. And so we would have to also provide the justifications that there's no competition concern. Or maybe one way that the parties may try to resolve it is to give that sort of a general undertakings that they will observe the competition law anyway. For example, agreeing that they would not, say, have that sort of price fixing, market allocation, customer allocation. So you will see that some of the behavior remedies in China actually they are more or less repeating the general principles under the antitrust law. And I think this is a way that the parties to give the assurance to SEMA that there will not be a collusion as a disguised way in the JV arrangement. And that could also be a quicker way to resolve the concern and obtain the approval.
Thank you, Janet. Very helpful. So turning to Canada, John, you've already made reference to the somewhat unique Canadian efficiencies defense. Of course, the various markets within the mining industry are fairly concentrated, so they would seem to be ideal candidates for making use of the efficiencies defense. Can you take us through the defense and some developments in Canada with respect to that defense and its use?
Sure, Tony. Well, back in 1986, Canada amended its competition law. It modernized it, in effect. Prior to 1986, mergers were treated criminally, and there were no merger challenges for that reason. To prove a merger was harmful to beyond a reasonable doubt in a criminal context was just not workable. So in 1986, when we modernized our law, our current merger control regime was implemented. And the economic thinking at the time was when the Chicago school was the rage, was economic efficiency should be the primary purpose of competition laws. And an efficiencies defense was built into our merger control process with the thinking that Canada, being a smaller country, had smaller economies of scale and some concentration needed to be tolerated so our Canadian companies could compete internationally against larger companies and in larger jurisdictions such as the US, for example. So that was the thinking behind an efficiencies defense. And I had the good fortune of being part of the first merger branch in the Bureau back in 1986. I hate to say it, a long time ago. And of course, officers that investigated mergers and found anti-competitive mergers were interested in seeing that there'd be some remedial action. But because of this defense that's available in Canada, whereby if the cost savings specific to the merger are greater than any economic harm from the transaction, the deal needs to be approved. So there was a number of files that the competition tribunal ultimately approved on the basis of efficiencies. One being Superior Propane that acquired ICG. These are the two national propane companies. And and the merger was near monopoly. And the tribunal, because of the significant cost savings of collapsing two transportation companies into one, and the efficiencies in delivery and etc., the savings were significant, much more so than an 8% price increase that we proved through modern econometric methods. And the tribunal approved the deal. And this was subsequently tested in another transaction involving hazardous waste disposal services in northern British Columbia, a case involving Tervita. That case went to the Supreme Court of Canada. The defense was confirmed, the procedures were clarified. And after that, the Bureau decided that it too would start clearing transactions on the basis of efficiencies, and has done so in another number of matters to date. And so there's been this lowering of the bar, if you will, in Canada of merger review and challenges because of the defense. However, one of the issues with efficiencies is that many of the claims that are made are not realized after the transaction. Sometimes it's these claims are made just to sell the deal to shareholders, for example. And so the current commissioner has wanted to challenge or test those claims more closely than just giving it a superficial look. And as a result, recently announced a new model timing agreement for any complex transaction where the Bureau has found that there is a serious competition concern, and they've made that finding. And if the parties want to claim efficiencies, that the parties needed to enter into a timing agreement to extend the review period beyond the statutory time frame of 60 days. And as a result, now transactions can be reviewed for over 100 days. As the Bureau conducted hearings of executives, hearings under oath to drill down on the claims that are being made, and also to have the opportunity to get the benefit of experts on business valuations, et cetera. So there's more of a thorough inspection, if you will, of efficiencies in Canada today than there may have been under my jurisdiction, for example. We really, we didn't take the word of the parties. We did do some testing, but they're doing it much more so now. So I think that's a significant development. So if parties are expecting to make these claims, they should expect a delay in the decision-making by the Bureau if they're expecting a clearance based on efficiencies. The other thing that we're seeing the Bureau do is look more at using interim relief and interim injunctions in its investigations, not only in mergers, but recently in a merger transaction involving Tomo Bravo acquiring Externa, which is a company that supplies reserve software to oil and gas producers. The Bureau engaged this interim injunction hold separate procedure to enable it to challenge the deal before the tribunal. But before they got to the full challenge, there was a remedy which basically replicated the whole separate agreement, and the matter was closed. But because of the use of this injunction, in my view, the deal, this whole process played out very quickly. It played out from notification to remedy in 4 months, which is highly unusual when a regulator digs deep into a transaction. So those are a couple of hot developments, if you will, in merger review in Canada over the past couple of years under Commissioner Boswell.
Thanks, John. So as Josh, in his description of the U.S. position, noted that non-reportable deals are nonetheless subject to challenge under Section 7. Like that, that's exactly the situation in Canada. The Bureau recently, I guess it was 2019, restyled its merger notification unit to call it the Merger Notification and Intelligence Unit. Can you give us a bit of background on that development and its implications for merging parties?
Yeah, so small merger review of small mergers is sexy again. Companies or agencies are interested in those deals now, and that's often driven by what the discussion around nascent firm acquisitions involving big tech. They have given pause to the agencies, think about maybe they should be reviewing smaller mergers in all sectors of the economy. So the Bureau has invested some additional resources into its merger notification unit to do some, I would call it monitoring of the marketplace through artificial intelligence. It has some AI tools that it's using now to help them detect mergers that may not have been reported that could be anti-competitive. So that increases their engagement of small mergers. In the past, they relied generally on complaints from competitors or customers of a small merger that may be anti-competitive. Now they have this additional tool. And since they've made this announcement of this investment, there have been a couple of public reviews that we've heard about that were involving non-notifiable deals, including this acquisition by Canadian National Railways of certain intermodal shipping assets of H&R Transport, which again, the Bureau looked at very, very closely, started formal inquiry, but ultimately approved the deal on the basis of efficiencies, which again, does happen in Canada, unlike any other jurisdiction around the world. So it's something to keep in mind. And the reason I think they're investing is that they're hoping that companies will come in voluntarily and report non-notifiable deals for review if there are some competition concerns, because there'd be nothing worse than closing the deal than having the Bureau commence a review, because they have up to 1 year to challenge that deal. And that would be very costly. The unscrambling of the egg, as Josh points out, is difficult but costly, but the Bureau would be prepared to challenge a consummated merger. And that, I guess, is what they're threatening to do through this new tool.
Thanks, John. Turning to Brazil, Amadeu, the CADE recently, the antitrust authority in Brazil, recently signed a cooperation agreement with the National Mining Agency in Brazil. What's that about, and what are the implications for merging parties?
Sure, Tony. So in Brazil, what we have seen in recent years, just by way of background, is an increasing scrutiny of mergers. We've seen transactions subject to remedies or even blocked more so than in past years. I would say within the last 5 years or so, we've seen a number of cases either blocked or subject to remedies, and that is something that we wouldn't see in the past. So against this background, the Brazilian Antitrust Authority has been focusing in regulated industries on getting opinions from agencies that specialized in such industries. That happened with the oil and gas industry, with telecom, and then more recently with the mining industry. The National Mining Agency, known as ANM in Brazil, has signed this cooperation agreement with CADE back in 2018. The effect of that is that CADE has been receiving much more data for the analysis of mergers directly from the ANM, and also non-binding opinions from the ANM. CADE is ultimately not bound by these opinions, but can and often takes into account these opinions. With respect to data, the interesting aspect is that the ANM will provide also data concerning mineral reserves that the merging parties have. And so CADE, it is likely that CADE will, in future mergers, also look at those markets as potential overlaps, meaning not just the markets where the parties have an actual output and an overlap in such markets, but also in markets where there's potential competition because the parties own reserves in Brazil, which is information that the ANM can provide. That means that the risk assessment of those transactions must be made carefully, also taking into account the data that the ANM would likely provide at the request of CADE.
Thank you. So you've already alluded to the increased scrutiny of transactions. I understand there are at least two illustrations in the mining sphere, the Vale Ferrous transaction and the ArcelorMittal Votorantim transaction. I wonder if you could comment on those and the lessons for merging parties that they offer.
Yes. So I'll start with the ArcelorMittal Votorantim transaction. And the reason I chose this one as an example is that it shows that CADE can be flexible with respect to remedies. Why is that? Well, in that transaction, you had very significant overlaps in certain steel markets in Brazil. The mining element of this review was the vertical integration with iron ore that ArcelorMittal supplies to the market and did supply prior to the transaction to Votorantim. And but the big antitrust concern did not relate to that vertical integration, rather to the very significant horizontal overlaps. The transaction was approved with remedies concerning divestitures in some of these markets, but that apparently was not sufficient. And the interesting element or additional piece of the remedies package was that the parties signed something called a performance commitment, where they would agree to keep production at a certain steel production at a certain level for a certain period of time, and the theory would be that they would keep, by keeping production at that seemingly high level, that that prices would remain low, which is, in my mind, a very unusual remedy for a horizontal problem, but it was accepted. So that is the point that I wanted to make, meaning more flexibility with respect to remedies, and I think parties should then take that into account when planning a merger in Brazil. The other case that I would highlight is the most recent one that attracted scrutiny in Brazil in the mining industry. That was the Vale Ferros case. That case was important because, well, it involved overlaps in iron ore markets. Those overlaps were relatively small, because Ferro's production of iron ore in each of the product markets that constitute the broader iron ore segment, Ferro's presence there isn't so significant. But the vertical integration was the issue here. We have the markets in Brazil for iron ore based from a geographic standpoint, defined around the infrastructure that serves to flow the products to the various ports in Brazil. One of the ports that was apparently harmed commercially by this transaction complained to CADE, and CADE ultimately approved the deal and simply dismissed the complaint as sort of a private, a complaint that was private in nature, that wouldn't merit any trust review. The party then appealed against that decision to CADE's tribunal. And that is precisely the aspect that I wanted to highlight, which is in Brazil, third parties that are admitted in the proceeding, they earn the right to appeal to the tribunal against a clearance decision by the superintendents. And that can substantially delay the review process in Brazil. So something that should have been cleared in, let's say, 60, 90 days, ended up taking much longer to be approved in Brazil by virtue of that procedural aspect of our law. So it's also an interesting element of Brazilian law to take into account when planning a merger in the country.
Thank you. That's fascinating. Okay, so turning to a panel-wide question, non-competition considerations, that is to say, considerations entertained, taken into account by competition authorities that are not, strictly speaking, competition considerations. They're not efficiency focused. They're not focused on competitive effects. Let me just canvass the panel and ask them, each panelist, the extent to which his or her jurisdiction involves those considerations. Now, I want to stress, we know that there are other agencies. For example, in the United States, there's CFIUS. In Canada, there's Investment Canada. We've just heard about the National Mining Authority and so forth. The real issue is, do competition agencies entertain non-competition considerations? Now, I'll start with Janet because she's already alluded to an issue in China in that regard. Over to you, Janet.
Yeah, thanks a lot, Tony. Yes, I think for China, we do take into account non-competition issues. For example, the foreign investment restriction. MOFCOM, in the past, they have imposed conditions based on foreign investment restriction, and the remedies imposed are actually talking about that you should not do the business infringing the foreign investment law, and there are special contractual arrangements called VIE, Variable Interest Entity, which it also mentioned that you should not, engage in this kind of contractual arrangement. So other than that, the second thing is, sometimes the stability of the local economy, especially if that may be employment issues, say after closing of a transaction, that there may be redundancy of the local company. That may also affect SEMA's review, but they do not intervene that, involve themselves directly into this kind of issues. What they will do is that they will put the review process on hold, and then at the same time encourage the parties to resolve those issues. But they would not proceed with the clearance unless those issues are resolved. And so this kind of non-competition issues, officially they do not want to take into account, but I think in practice, with their reluctance, they would have to do something.
Thank you. Josh?
I'll be brief. No. And to elaborate just a bit, at least for the FTC and DOJ and the competition, the merger review, only non-competition concerns aren't part of the process. They are sort of become part of the process, as you alluded to, if there is sort of a parallel review by another agency, certain mergers. Obviously, CFIUS has a political component to it. But other agencies, for instance, in transportation, you'd have to have it reviewed not just by the DOJ, but also by the Department of Transportation. And that's a different standard, a public interest standard, which can take into account more than just competition concerns.
So for just a bit of fun, Josh, there's no temptation in the United States to support national champions. Is that right?
That's correct. That's
okay.
Correct.
I see we've got just a couple of minutes left, so I'll ask Amadeu, can you comment for Brazil, non-competition considerations?
Sure, Tony. So Brazil, I think, is pretty much immune to political considerations in a merger review process. The Antitrust Authority has held a long tradition of remaining independent and insulated from political influence. They've also refrained from taking into consideration non-antitrust elements in their analysis. The example that we have that's a more recent one about this is the Vale Ferros case that I was just commenting on. In that case, because it involved Vale, the mining company that had some accidents in recent years, including the collapse of a dam in a city in the state of Minas Gerais. Because of that, in the process, there were private organizations that were complaining to CADE and asking CADE to take into account environmental law issues in the analysis and request that the transaction be approved subject to remedies consisting in fulfilling certain environmental and social obligations. And CADE ultimately dismissed those and said, well, this has nothing to do with competition law. There's no place for this in our analysis, reaffirming its tradition.
Thank you. And John, to take us to completion.
So yeah, like Brazil and the United States, Canada's Competition Bureau is an independent law enforcement agency that operates at arm's length from the politicians, the ministers, if you will. It treats its companies that are merging in an agnostic fashion. As I mentioned, we have this baked-in deficiency defense that helps support in a larger Canadian company so they can compete. So to a certain extent, that is a public interest consideration, someone could argue. There are a couple of sectors, however, where the Bureau does overlap with other sector regulators, if you will. For transportation undertakings, any merger in that area, those deals need to be filed both with the Competition Bureau and our Transport Department, who will consider public interest considerations in its deliberations. Most recently in the Air Canada Air Transat deal, the transport regulator approved the deal, subject to some commitments regarding employment guarantees, for example. So there is some public interest considerations by them. In addition, our financial services mergers ultimately approved by the Minister of Finance, who can consider public interest considerations such as systemic risk and security on deciding whether or not to approve a bank merger. The Bureau will participate. It will do its objective review, provide its advice. Then it'll be up to the minister to make the call, including public interest considerations. But for the most part, the process is pretty agnostic. The Bureau's colorblind. They're not like figure skating judges, that have that built-in bias for their own home team. That doesn't happen in Canada.
Thank you, John. Well, that brings us to the end of our program. I want to begin by thanking our audience for their time and attention. Thank you to our panelists for their insightful comments and the great efforts they went to bring this program to fruition. I bid you a good day and stay well. Thank you.